Here is yet another example to show you that Judge Aileen Cannon's corruption is matched and perhaps exceeded by her incompetence. Here is a new minute order that Judge Aileen Cannon in the Southern District of Florida just issued. Just to remind you, she's the judge that's presiding over the federal case against Donald Trump for the willful retention of national defense information, where Trump stole top secret information and sensitive compartmented information and wouldn't turn it over when it was discovered that he stole things that didn't belong to him. Give them back, Donald Trump. No, mine. I can do whatever I want. But let's take a look at this minute order issued by Judge Aileen Cannon. Here's what it says. Paperless order. In advance of the upcoming CIPA Section 4 hearings, and to assist in the court's evaluation of defendant's motion for access to CIPA Section 4 filings, the court hereby schedules a hearing with special counsel on January 31st, 2024 at 10 a.m. This hearing shall be conducted on a sealed ex parte basis in a facility suitable for the discussion of classified information contained in the special counsel's Section 4 filings. The court reserves ruling on defendants' motions for access to CIPA Section 4 filings pending the February 2024 CIPA Section 4 hearings and review of defendants' forthcoming CIPA Section 4 challenges, signed by Judge Aileen Cannon. So, what does all of that mean? CIPA, remember, is the Classified Information Protection Act. It's to ensure and protect that classified information that doesn't belong in the public fora gets leaked out there, and that classified information be treated differently than normal discovery in criminal cases. So CIPA Section 4 is a sealed ex parte hearing where the criminal defendant is not allowed to attend in general. That's what CIPA Section 4 is. So just to be clear, in criminal cases, there's a due process right. There's also a Sixth Amendment right. There's all of these rights that criminal defendants have to get discovery, to get documents that are relevant to the case, that are what's called Brady material, that would be exculpatory evidence, and the government has to produce all of this evidence. But what happens in a case where there's highly sensitive and classified information, where if you turned it over, as you know, you're supposed to turn over records in a criminal case, it could actually jeopardize our national security. And then wouldn't a criminal defendant, knowing that, try to utilize that to blackmail the government or graymail the government and say, if you don't dismiss this case against me, you have to turn over this national security records and I'll make it public and I'm going to harm the national security, or else you could dismiss this case against me. So Congress enacted CIPA to address these concerns. And so you have like CIPA Section 3, which is a special protective order, an agreement that's entered in these cases specifically for how these highly sensitive documents are handled, where they can be viewed. They have to be viewed in SCIFs, sensitive compartmented information facilities. How do they even get transported? There has to be these special security officers who handle classified information for a living, who actually deliver the documents. They don't get filed on the normal docket. How do you transport and hold these documents? All of that is part of CIPA. Then you have CIPA Section 4, which says there are some documents that are so sensitive that even if you have this CIPA Section 3 protective order in place that protects these documents from the normal way they're handled in criminal cases, the government says, we're not turning these documents over. These documents are not helpful in the case, and if we turned them over, they could pose some real serious harm to our national security. So who decides whether they have to get turned over or not? In the first instance, it's the district court judge. It's the federal judge. In this case, it's Judge Aileen Cannon. And if this case was filed or other Classified Information Procedure Act type case or Protection Act cases are filed in other jurisdictions, they would go before those other federal judges who are assigned the case. But here, Mar-a-Lago is based in the Southern District of Florida, federal district court's jurisdiction. So Jack Smith had no option but to file in this courthouse, and it got assigned to Judge Aileen Cannon, and the assignments are done on a random basis. And so that's how we arrived here. So CIPA Section 4, though, is always done on a ex parte, under seal basis, what's called an in-camera review, where the criminal defendant and the criminal defense lawyers are not allowed to be present. Why are they not allowed to be present? Because if they were present, it would defeat the whole purpose of CIPA Section 4, which says there are certain instances where the government can withhold certain documents from production and discovery because of their national security interests, combined with the fact that it's not helpful in the case, and the judge is to make that decision. Once the judge makes the decision that a document can be withheld, then there's discussions about, do you need to do some sort of substitution or a summary of the document, a written summary? These documents involve nuclear codes. These documents involve war plans, but not actually turn over the war plans. And if you're saying, well, Judge Aileen Cannon's always going to get it wrong, she's always going to say Trump should have access to it, all of these issues when it comes to CIPA are immediately appealable on interlocutory review to in this case, the Court of Appeals would be the 11th Circuit Court of Appeals, to review what Judge Aileen Cannon's doing. But Judge Aileen Cannon has not made any actual orders other than these weird paperless scheduling orders like the one I'm just showing you right now. So these paperless orders shifting the dates and moving the dates and all these kind of machinations, those are not subject to interlocutory appeal. And by the way, if you've been building on the logic we've been teaching here in our legal knowledge, what's the case that talks about interlocutory appeal review? Midland Asphalt. Remember the case that was cited before the D.C. Circuit Court of Appeals in that American oversight brief? If there is a statute or strict constitutional basis for an interlocutory review, then you are allowed to have it. If not, you shouldn't have an interlocutory review. That's why the amicus brief argued in the D.C. Circuit Court of Appeals that Trump's absolute immunity appeal was not subject to interlocutory review by the Court of Appeals because there's nothing in the Constitution that mentions it. But when it comes to CIPA, in the statute, in the law itself, it talks about interlocutory appeals before the 11th Circuit. So that's based in the actual statute. If you're like, well, I think Judge Cannon's going to get it wrong. That's why she's doing all these paperless orders, to try to avoid actually making a ruling that she should have to make.
What if you could support small family farmers and reduce your environmental imprint, all while enjoying the highest quality meat on earth? When you join the Moink movement, you can. I'm so excited to tell you about Moink. That's Moo plus Oink. Moink is a meat subscription box company on a mission to fight for the family farm. They're located in rural America, run by an 8th-generation female farmer. Their animals are raised humanely, their employees are paid a living wage, and the quality of their product is better than anything you'll find in a store. Moink delivers grass-fed and grass-finished beef and lamb, pastured pork and chicken, and sustainable wild-caught Alaskan salmon straight to your door. Moink farmers farm like our grandparents did, and as a result, Moink meat tastes like it should, because the family farm does it better, and the Moink difference is a difference you can taste. Unlike the supermarket, Moink gives you total control over the quality and source of your food. You choose the meat delivered in every box, like ribeyes to chicken breasts, to pork chops to salmon fillets, and much, much more. Plus, you can cancel at any time. We here at Legal AF are unapologetically pro-democracy, and it's so amazing to know that Moink is helping save rural America. I love it, and you will too. Join the Moink movement today. Shark Tank host Kevin O'Leary called Moink's bacon the best bacon he's ever tasted. And Ring Doorbell founder Jamie Siminoff, he jumped at the chance to invest in Moink. Plus, they guarantee you'll say, oink, oink, I'm just so happy I got moinked. I know I do, and you will too. Keep American farming going by signing up at moinkbox.com/legalaf right now And listeners of this show get free ground beef for a year. That's 1 year of the best ground beef you'll ever taste, but for a limited time. Spelled MOINK, box.com/legalaf. That's moinkbox.com/legalaf.
So here, when Judge Cannon is basically saying, in advance of the upcoming CIPA Section 4 hearings, and to assist in the court's evaluation of defendant's motion for access to CIPA Section 4, the court hereby schedules a hearing with the special counsel on January 31st, 2024. This hearing shall be conducted on a sealed ex parte basis in a facility suitable for the discussion of classified information. So what she's discussing, but trying to throw like a favor to Donald Trump, she's actually talking about what a CIPA Section 4 hearing should be. What she's saying on January 31st, 2024 is that she's going to hold this in-camera ex parte under seal hearing where only the special counsel's office is going to show up, and she's going to review the documents with them, which is what CIPA Section 4 says. But then she goes to then determine or to reach a conclusion on Donald Trump's request, on the defendant's request for access to the CIPA Section 4 filings. And let's be very clear. They don't have access to the CIPA Section 4 filings. It's built into the CIPA Section 4. They don't. It's ex parte, it's in camera, it's under seal. The defense doesn't have access to it. Now, if there is a ruling by Judge Cannon that the material that she sees during the CIPA Section 4 hearing is information that she believes cannot be withheld, she says this is crucial evidence for Donald Trump or whoever the defendant would be, and it's very helpful, and on balance, the national security interests don't outweigh that factor. I'm turning it over. You make that decision in the under seal hearing without the defense, and then you turn it over to the defendant under the protective order, which was entered into under CIPA Section 3. Before that would happen, though, you certainly would have an appeal taken by special counsel Jack Smith's team or whoever was representing the government in a specific case, whichever prosecutorial team was representing him. You would stay Judge Cannon's order, pause it, go to the 11th Circuit and go, whoa, the district court judge just made a terrible ruling in the CIPA Section 4 hearing. Stop what Judge Cannon's doing and reverse it. These documents cannot be turned over in the case. That would be the natural progression. But Judge Cannon's creating like these other steps. She's like, before we hold the CIPA Section 4 hearing, so I can determine if Donald Trump's lawyers should appear at the CIPA Section 4, I'm going to hold like my own version of a CIPA Section 4 hearing to then determine if Trump should be in the CIPA Section 4 hearing. But what Cannon's really just talking about is a CIPA Section 4 hearing in general, because Donald Trump's lawyers are not allowed to be in the CIPA Section 4. It's just that clear. This is what CIPA Section 4 says. The court, upon a sufficient showing, may authorize the United States to delete specified items of classified information from documents to be made available to the defendant through discovery under the federal rules of criminal procedure, to substitute a summary of the information for such classified documents, or to substitute a statement admitting relevant facts that the classified information would tend to prove. The court may permit the United States to make a request for such authorization in the form of a written statement to be inspected by the court alone. To be inspected by the court alone. If the court enters an order granting relief following such an ex parte showing, the entire text of the statement of the United States shall be sealed and preserved in the records of the court to be made available to the appellate court in the event of an appeal. And so what CIPA Section 4 says is very clear. So when Judge Cannon says, I want to hold a hearing first, just speak to the government, take a look at the documents, then determine, there's nothing at that first hearing that will ever lead to a conclusion that Trump should then be at a CIPA Section 4 hearing that he's not allowed to be at. Nothing can happen at this January 3rd, the 31st hearing that could change the judge's mind. So what is she doing right now? Playing games, doing more of these paperless orders to just completely delay the inevitable that she will soon get turned over, reversed by the 11th Circuit Court of Appeals when she actually finally makes an order. And she's trying to learn on the job here because she doesn't know what she's doing. She's never handled a CIPA case before. And if she did, she would do what Judge Tanya Chutkan did. Donald Trump made these same types of frivolous arguments before Judge Tanya Chutkan. Judge Tanya Chutkan entered an elegant minute order very early, said, look, I'm willing to hear from you, Donald Trump and your lawyers, why you think you should participate in a CIPA Section 4 hearing, despite the fact that every case everywhere and the plain statute says you can't. If you can convince me otherwise, you can come into the CIPA Section 4. And then obviously Trump couldn't. And she said, no, you can't come into the CIPA Section 4 because that's simply not what is allowed by the statute, by its plain language here. But we've seen Judge Cannon do this over and over again. She's set these hearings on CIPA Section 4 in February, mid-February. Then we've got pretrial motions, February 22nd, 2024. That's when Donald Trump is going to file a slew of motions to dismiss on all of these various grounds. And then we have a scheduling conference on March 1st, 2024. I've said this before, I'll say it again. I expect that Judge Aileen Cannon, we could expect her in February, just based on what she's doing now. All of this will come to a head because you can't keep creating these bizarre paperless orders that don't do anything. You can only do that for so long. So eventually she's going to have to make an actual ruling. And she's already set up her rulings for her to be reversed eventually. Jack Smith knows that. But as I said, I expect Judge Cannon to dismiss. I do expect her to grant Donald Trump's motions to dismiss the case when he files that. I don't expect her to do anything right there. And I expect that she will eventually make the wrong ruling on CIPA, and she'll allow Trump's lawyers, I think, to show up at the CIPA Section 4 hearing. But don't worry, that becomes immediately appealable. And then finally, Jack Smith can go to the 11th Circuit Court of Appeals and say, stop it. Look at all this chaos that was created. She's setting hearings that don't even exist. Like, again, this CIPA Section 4 precursor thing that she's setting in this minute order, it isn't a thing. That doesn't exist. You have CIPA Section 4, that's it. Then you go to CIPA Section 5, then you go to CIPA Section 6. There's an orderly process to this all, and she just doesn't know what she is doing. And that's why, even though she still has her trial date scheduled for May 20th of 2024, there's a status conference scheduled for March 1st of 2024. She's going to get appealed before then, and that will stay the trial date. And then what I think will happen is by the time the D.C. Circuit Court of Appeals rules, which is going to happen soon, that Trump doesn't have absolute immunity, by the time that gets through the United States Supreme Court, Judge Cannon's orders are going to get reversed. She's going to get stayed. And then pending that, and then I think you'll actually see the DC case take place sometime in that May time period would be my prediction as of now. And then before that, we have the Manhattan District Attorney case in New York. We'll see if that one goes first on March 25th, where it's currently scheduled for as well, for Donald Trump's falsification of business records. We'll keep you posted. Hit subscribe. We're on our way to 2 million subscribers here at the MeidasTouch Network. Let's get there this month. Thank you for watching.
Hey, Meidas Mighty. Love this report? Continue the conversation by following us on Instagram @MeidasTouch to keep up with the most important news of the day. What are you waiting for? Follow us now.